All right. Good afternoon, everyone, or good morning to anyone that is further west in the Eastern time zone. My name is Tripp VanderWal, and I am a partner in Miller Johnson's Employee Benefits and Executive Compensation Practice Group. Welcome to our monthly benefits lunch break webinar series for June. For those of you who haven't attended these webinars before, please note that we try to hold these monthly and plan for noon Eastern time on the third Wednesday of each month. So on this slide, you can see where we have the proposed dates for our upcoming monthly webinar series. We're always looking for ideas. We've had a lot of or topic ideas. We've had a lot of content that we've wanted to talk about already, but I am sure that we will, start running low on ideas and would appreciate your feedback about what you would like to hear. There's already some topic selection or suggestions that we've heard in past webinars that we've noted and are going to try to schedule in some future content. With that, I am happy to welcome to the podcast, or to the, podcast, the webinar. I use these terms interchangeably, I guess. My partner, Jeff Gray. Many of you probably know Jeff. He has been on this webinar before. Jeff is also in the Employee Benefits and Executive Compensation Group. He focuses on more on retirement and executive comp plans. And I also have another partner, Jason Crow. Jason Crow is I think technically a litigator, but is also the head of one of the co-heads of our cybersecurity and privacy and cybersecurity practice group. And since we're kind of dealing with cybersecurity issues with retirement plans, we thought it would be helpful to have Jason join us and talk to us, I guess, more from a cybersecurity standpoint. I think this is obviously a hot topic right now for a couple of reasons. One, we have brand new DOL guidance on cybersecurity issues as that relates to retirement plans. And frankly, we've seen a lot of, cybersecurity incidents with the pipeline on the East Coast, and then there was a meat processing plant, I think, that were both victims of some type of ransomware attack. So this is certainly an issue that I think is at the forefront of everybody's mind. With that said, I will turn it over to Jason. Jason, take it away.
Actually, Tripp.
Oh, sorry. Another mess up. Not a podcast. It's a webcast, and I'm turning it over to Jeff before Jason.
That's all right.
Apologize.
That's all right. Thanks, Tripp. Yeah, I thought I'd just spend a couple minutes here kind of setting the stage, because I did talk a little bit about the cybersecurity guidance back in April. So yeah, today we're talking about cybersecurity as it relates to retirement plans. And on April 14th, the Department of Labor issued 3 issues of cybersecurity guidance, 3 documents. They're titled Cybersecurity Best Practices, Tips for Hiring a Service Provider with Strong Cybersecurity Practices, and Online Security Tips, which were directed mainly towards participants. Jason's going to talk about those in more detail, but I wanted to talk a little bit about sort of why we're covering this a second time. The upshot of these documents is that in the Department of Labor's eyes, employers have a fiduciary obligation when it comes to protecting participant data and participant assets from security breaches. And so the question is, why are we talking about it again? Well, we thought it'd be helpful to hear from an actual cybersecurity and privacy expert, which would be Jason. I work mostly with retirement plans, and this is an area where these 2 areas overlap. But let's also remember kind of the definition of prudence under ERISA. This relates to fiduciary duties. One of those duties is the duty of prudence. And what does it mean to be a prudent fiduciary? Well, it means to act as a reasonably prudent person who is familiar with such matters. I'm kind of emphasizing that because that's from the statute, familiar with such matters. And so that phrase is really why we're here today. We use that phrase, we often refer to it as the prudent expert rule. And so the idea is once you have a fiduciary duty here, there is no empty head and pure heart defense. There's a requirement that employers are aware of these issues in more detail. So that's really the background to why we're talking about this again. And when I talked about it previously, we gave kind of a general overview. The hope today is to have more specific and sort of actionable guidance for employers towards the end of the presentation. So with that, I'll hand it over to Jason.
Great, thanks, Jeff. As Tripp and Jeff mentioned, I'm the co-chair of the Privacy and Technology Transactions Group here at Miller Johnson. We started the practice group about 6 years ago now, and we've kind of seen cybersecurity and data breaches and fraudulent wire transfers and all of those things that are impacting retirement accounts become more and more prevalent. So we worked on 50 or more data breaches. We've worked on almost as many wire fraud transfers. We work with the U.S. Department of Homeland Security, the FBI, the Department of Justice, all in trying to claw back those funds and get fraudulently transferred funds back to the plan participant, back to the person who's been defrauded. So we've been on the front lines of this, and we've been successful sometimes getting money back. We've been unsuccessful. We've also litigated these matters in state and federal court. So we've got the experience and expertise to kind of hopefully give you enough practical advice to avoid having to talk to myself or any of the partners in our group. So what I want to briefly do is kind of run through the DOL guidance, do kind of a 101 here, just to refresh everybody's recollection. So Jeff mentioned that they did a 101 on the new DOL guidance. So on April 14, 2021, the U.S. Department of Labor, we're calling the DOL, through the Employee Benefits Security Administration, finally announced new cybersecurity guidance for plan participants, plan sponsors, and plan fiduciaries. So our clients here at Miller Johnson kind of match up across the spectrum here of plan participants, plan sponsors, and plan fiduciaries. So we've personally advised all three categories. So we've been on the side of the entity that's holding the money. We've been on, we've represented and advised plan sponsors, the employers. We've represented employees and other, as well as other plan fiduciaries. So we've kind of worked through it all here. And what does the DOL guidance generally provide? And when it came out in April, there was a lot of commentary about it because there's been a decent amount of federal litigation related to fraudulent wire transfers out of retirement accounts. And so that litigation kind of winding its way through federal courts has been, has put the urgency around the DOL providing guidance so that everyone is kind of on the same page as to what is prudent and what is not necessarily required from a plan fiduciary, from a plan sponsor, in connection with hiring someone to manage retirement fund assets. So everybody was, all the lawyers, and I think the judges were hoping the DOL guidance would put to rest kind of what is exactly required under a fiduciary's obligations to act prudently. And I think what we found in the guidance is that there is some guidance, right? It's called guidance. It's not called all the answers. But in the guidance, we find some good insights. So, what does a plan sponsor need to do in order to prudently choose a service provider in connection with, retirement accounts? So, just kind of marching through some of these bullets, ask about the service provider's information security program, audit results, compare them to industry standards. Ask the service provider what levels of security standards it has met, evaluate its track record, ask whether it has experienced past security breaches. This slide I sum up as the you have to care about cybersecurity slide. And when clients call me up and they say, I'm at the beginning of my cybersecurity journey, I don't even know where to start. What's the law? What do I have to do? What do I have to figure out? I say, well, you've accomplished the first step. You have to care. And I think that's what the DOL is in its guidance is saying here, which is just, look, if you were going to, hire someone to build your house, you would want to know, if they are licensed, if they have insurance, if they're have experience building houses, do they know how to build a house? Have they done it safely for years? It's the same sort of thing. If you're hiring someone to manage assets, and a lot of these retirement plans will have, hundreds of millions of dollars in them. We've dealt with, plans that have, several billion. So there's a lot of money at stake. So you have to care about it. So that makes sense, right?
So Jason, retirement plan, people who work with retirement plans, they see the words audit results. They might be thinking of the annual financial audit, for example. When we talk about audit results, what are we talking about in this context?
That's a really good question, Jeff. So every year, folks have an opportunity, companies that hold assets have an opportunity to conduct a information security audit. And, what's interesting now with the DOL guidance is that an audit, a information security audit, a cybersecurity audit, I think is now going to become essentially required by law, so to speak, right? So for a long time, it was best practices. It was part of what would be a prudent action to take if you were a bank holding these assets. And these audits come in all shapes and sizes. So, right now there's, a lot of service providers that will provide information security audits, cybersecurity audits. And, some of the gold standard audits are related to SOC 2, Type 1, and Type 2 audits. And, if the asset holder, the bank, isn't conducting a SOC 2, Type 2 audit or something similar, and they're not, able to produce the results of that audit to you very quickly, you should be concerned.
Yeah, I think some of our employers, they'll get audit results that might be an audit of, say, the plan's internal controls, but it really doesn't cover any cybersecurity. So it sounds like, based on this guidance, it makes good sense to ask for those actual cybersecurity privacy audits that are being done.
Absolutely, and it's a big business now, if you can imagine. And there's a lot of them, a lot of types, a lot of them being done. And what's great is if you're a plan sponsor, I think you just ask for this information security privacy audit. You don't even have to say the magic words. If the entity you're asking, requesting the audit doesn't know what you're talking about or can't just produce it quickly, I think the red flag should be raised, and you should, wonder why they're just not on top of it. And what these audits generally will do is, they'll look and they'll say, okay, they'll ask, does the entity have a password policy? And a lot of times it doesn't get as granular as what type of password policy, but it's like, do you have a password policy? The second level of that would be, do you have a password policy that meets an international ISO standard? Or the current US standard would be under NIST. NIST has its own password. So the report, you may need to get an NDA for them to share it, but they should be able to share it with you, and it'll show at a high level whether they have a true information security program or not. So that's kind of the long and short of this, caring about a service provider's cybersecurity program. Another key thing is, I negotiate a lot of agreements and even specifically agreements related to a bank holding large amounts of retirement assets. And one of the questions that we always ask is, what is your cyber liability insurance policy? What's your per claim limits? What's your sub limits? What's your retentions? And now, nowadays, you should almost be asking that of every service provider that handles any type of sensitive data that your organization is dealing with, right? And this one very large bank, responded. I requested something like 250 million in coverage for this, $1 billion set of assets, and they were very polite, but they said, look, we're self-insured up to like several $billion. But not every bank is going to be like that, right? And so, asking about what their cyber, having them provide the policy is not outrageous. It's not super confidential, and taking a look at it. So, and then second, asking about, data breaches, wire transfer fraud. So, how many data breaches have you experienced? And, have those data breaches been reported to regulators? Were they reported to plan participants? That sort of thing. So in this next slide, we're talking about, additional kind of what plan sponsors, what the DOL guidance provides in connection with plan sponsors. So plan sponsors should ensure that fiduciaries and administrators have a formal, well-documented cybersecurity program. In my line of work, we call them WISPs, right? So it's a written information security program. It's not just a director of IT's, greatest hits in his mind or her mind as to what an information security program should look like. This is written down, and this has a statement at the beginning that says, we care about cybersecurity and about protecting the security of your information. Plan sponsors should ensure that there's these annual risk assessments. So, those SOC 2 type 2 audits, they exist as a snapshot in time, and they kind of discuss what's there and what's not there. Risk assessments are potentially a little deeper. So you could do, a pen test, for instance, hire a third-party service provider to see if there's any open ports on your network that allows a bad guy to get in. And that type of risk assessment is kind of what I would say, you got SOC 2 type 2, that's kind of a Q&A. A risk assessment could be a second level where there's actually kind of hacking going on, white hat hacking. Clearly define and assign information security roles. So asking an organization if they have a privacy officer, if they have a CISO, a chief information security officer, do they have kind of the business side of information security handled and managed? And do they have the tech side of information security handled? Training. So this next slide talks about training. I actually think, when my partner and I go around giving these presentations, we like to start with the data, oftentimes, about data breaches. And we didn't do that here. We have a little bit shorter time, so I didn't want to sit and talk about the data. But, data breaches are happening all the time, right? There's thousands and thousands. We hear about Colonial Pipeline. We hear about JSP. Well, guess what the data shows? The data shows that the number one cause of these data breaches is human error. So everyone thinks that cybersecurity is, all about the tech stack, the computers, the technology. Well, it turns out it's the human use of that technology that causes wire fraud and wire funds transfer fraud and other types of data breaches. And so we go around and we do a lot of training of the number one cause of these problems. We train human beings. So I would say organizations, plan sponsors can do their own internal training, because as they're working with plan administrators and the holder of the assets, if you haven't already been trained on how to prevent cybersecurity incidents, you may not know what to look for with your service providers, and and encouraging them and monitoring them and prudently, managing them in connection with preventing data breaches. So, if there's kind of one thing, that can prevent data breaches that is actually relatively inexpensive, is training.
I think we have this case that's pending right now with Abbott Labs, and I think the allegation in that case anyway is that the record keeper staff received a call from a thief who had gotten some participant data and was calling in trying to get a distribution, and that staff member basically validated the participant's home address by describing it on the phone to the thief, sort of like, is this your address? Here it is, giving the whole address over the phone. And of course the thief says, yeah, that sounds right. That's exactly my right address, or whatever it was. He used that information to then be able to take a distribution. So that sounded like purely human error. And I suppose it makes sense. The guidance talks about these issues in the context of vetting your service providers to make sure that they have training and make sure that their staff don't make those types of mistakes. But it sounds like what you're saying is it also makes some sense on the plan sponsor side to have at least some level of training about cybersecurity.
Absolutely. And it really, I think plan sponsors should, have a culture of cybersecurity awareness, information security awareness, because, the weaknesses happen at each link in the chain. So whether you're at the plan sponsor, or you're at the plan administrator, or you're at the holder of the assets, there's a lot of humans in that chain. And, the thieves are trying to manipulate every weak link in the chain. And you're exactly right. Abbott Labs is a case that we've been watching for some time out of the U.S. District Court for the Northern District of Illinois. And, that case is interesting because the court dismissed it, stating that the complaint's conclusory statements failed to sufficiently allege that Abbott was a fiduciary. And then, they also go on to find that, that although the plaintiff claims that Abbott defendants were imprudent for hiring this call center, basically, that handled that call that you're talking about, where she just read aloud the address to confirm it. So basically they said, look, this administrator, Abbott, was imprudent when they hired that third party, and they didn't monitor them, right? They didn't require potentially training. They didn't do these things. And what the court found was that, Abbott hired this company 10 years before these incidents happened. And that the court cannot infer that the Abbott defendants breached their duty of prudence by hiring the company in 2003 based on events a decade later. And basically, the court even found that renewing the contract in 2015 wasn't, quote, objectively unreasonable. And so I think, this is, this case was decided a while back, right? And before this DOL guidance. And so it's interesting to think what the court may have found now if they had the DOL guidance.
Yeah, and it's a district court opinion. I think it could still be appealed. It could still change. And part of the goal here is to just avoid even giving someone those facts to be able to allege in a case like that. But yeah.
That's right. And, if you read through the facts, it was a really sophisticated ruse. They somehow got access to the account, put in a new bank account. It was supposed to sit there for 7 days before any funds could be transferred. So the thief called back a week later, and then I believe there was an identity theft so that the thief could monitor the participant's account and receive a confirmation email. So there was what we call two-factor authentication before this transfer happened. where a passcode went to an email, and so, you know, the thief had, I would say, like wide access or significant access to the participants' accounts, email account, retirement account, was super sophisticated. But, you know, I guess what I want to stress here is these aren't isolated instances. The fact pattern in Abbott is stuff that we're dealing with, you know, routinely here at Miller Johnson. And so, you know, this idea that, you know, training is, you know, is going to distract too much from the plan sponsors day to day. It's going to maybe distract too much from what's going on. You know, in my mind, it's essential to kind of preventing these sorts of things. And you know, I think as courts start addressing this DOL guidance from April, you're going to start to see, I think, instead of cases settling, which they tend to do these days in connection with these ERISA-based claims, they're going to potentially start surviving motions to dismiss. And that's when you're going to see, you know, more and more of this guidance become actual requirements at, you know, across the spectrum between plan sponsors, plan administrators, plan fiduciaries, et cetera. So, you know, if we start looking, you know, we can kind of continue to walk through these slides. You know, there's some guidance on encrypting sensitive data stored and in transit, implementing strong technical controls. This is all plan sponsors ensuring that the service providers that they're working with have all these things in place. You know, on this previous slide, I talked about having a business continuity, disaster recovery, and incident response plan. You know, here I equate that to, you know, when you're in a big office building, you know, every month or every 3 months they do a fire drill, and you sit there for a few moments and you think, okay, what would I do if there was a fire? Where's my exit? This is one of those things. And, you know, the benefit of going through, you know, addressing your business continuity disaster recovery plan, whether it's at the plan sponsor level or the plan fiduciary level, is that you'll know what to do the moment you get a call that a retirement account has been compromised. And you'll be ready to respond. You'll know what cyber insurance you have and what you don't have, whether the plans, you know, does the plan sponsor's cyber insurance kick in? Because it was a plan participant's, you know, account that was hacked, or you know, or is it the fund holders cyber insurance, or is there subrogation involved, right? Or ultimately I say, let's put all the insurance policies on the table and let's notify them all and see who pays. So walking through that process can really help overall with just managing your cybersecurity posture, your information security posture. So, you know, here's what, you know, the DOL guidance says: additional guidance for plan sponsors and administrators as advising participants to do, right? And this goes back to my whole training point. So here's a whole section on what participants should be doing. And, you know, by conducting training, and you can do it, you know, we've used various vendors, but you can hire an online trainer to conduct what I would call sort of low impact on the company cybersecurity training. And it's essentially where, you know, you can send out phishing emails, fake phishing emails to your company. You can find out who's going to be clicking on them, and then whoever clicks on them gets a small video training, right? And those, you know, can be run by the IT department. It doesn't take a lot of time. It's not hugely expensive. You can run one for like, you know, $3,000 a year, $2,000 a year. And all of those things, you know, monitoring your online accounts, making strong passwords, using multi-factor authentication, closing or deleting unused accounts, all of those things get addressed in the process of someone falling victim to a spear phishing campaign.
I've seen those too, where you then break down the results based on department, and it creates a little competitive aspect to the whole thing, where you don't want to be the department that's at the bottom of the list of clicking on those phishing emails.
Yeah, that's exactly right. And I had a client that put together a T-shirt for the department that had the best results.
There you go.
And the shirt says, only you can prevent cybersecurity incidents. And then there's a little drawing of the chief information security officer's face, pointing the finger. And, it can be, it makes it a little more fun, right? No one likes to lose their lunchtime training or find out they clicked on a bad link and then they're getting a call from HR. But you can make it fun. Around here, we have little giveaways, some water bottles, whatever, gotta make it fun.
So as we're kind of wrapping up here, let me ask you a couple just practical questions that I think we confront in the retirement plan space.
Sure.
Can
I interject one thing?
Sure.
And before I let Jeff kind of roll off the questions, one thing I did forget to announce when we started is you can put in, if you have questions, the audience here, feel free to enter those in the Q&A and we will try to address those as time allows. With that, I'm sorry, Jeff, but I just want to know that our audience members had the opportunity to ask questions too.
No problem. Some of our employers, they may be on the cusp of negotiating one of these agreements with a record keeper, but many of them have had kind of long-standing relationships with record keepers going back maybe 10, even 15 years, which may itself be a different problem, but those do exist. And those contracts were, of course, negotiated long before cybersecurity really was an issue. And I guess the question is, what should we be telling clients about approaching those vendors now, given that this guidance has come out?
No, that's a great question. And it's one of the reasons why I stay busy at the firm these days, because what we advise clients to do is, you start the conversation this way. You say, we're increasing our own information security posture here at the company. And, we're doing A, B, and C. And, what we'd like to do is just add an addendum to this record keeping agreement. That's the data protection addendum. Now, folks on the call that dealt with GDPR back in 2018, that was a regulatory requirement, was to have a DPA, data protection addendum.
GDPR, just for people listening, that's like the global privacy thing.
That's the European that's right, the European global privacy law. So when that came out, all of a sudden, I had 50 of these DPAs sitting on my desk, and everybody's saying, do I enter into them? Do I not? What do I have to do? Well, here we don't necessarily have a GDPR in the United States, right? What we have is a patchwork of state laws. And you may find, like in Colorado, there is a requirement for you to manage the cybersecurity posture of your vendors through contractual agreements. In fact, they just passed a new law January 8th. It's going to be signed by the governor in Colorado. This specifically requires data protection agreements to be entered into if someone's handling your sensitive information. Well, I would think now, given that the states are already moving in that direction, we've got California, Virginia, and Colorado already doing that. We've got the DOL, who's now given this guidance that basically says, you need to manage your vendors. Well, how do you manage them? Well, through contract. That's where the teeth is, right? So if they have a rep and warranty, so to speak, that they're going to protect your data, then they've got to abide by it. And then when they don't, you have something to hold them to. So I would say, what we have is we have a template form that we give to our clients that's like a page and a half. And it basically lays out, and Tripp will know this very well, the physical, administrative, and technical safeguards to protect your data. And those safeguards, are not listed out. You gotta have this firewall, you gotta have this password policy, you gotta, they're not specific, but it's very general, just like in kind of the old HIPAA high-tech guidance. You need to have those technical, administrative, and physical safeguards in place to protect our data. And, putting that in a little DPA, or even, we've even got one paragraph. We've kind of narrowed it down to one paragraph that says basically that, and then says, and oh, by the way, you will comply with all relevant data privacy laws. So in the rest of the agreement, it may say you have to comply with EBSA and all laws. But now we're in that phase, I think, of data privacy and data security where there's a separate provision for that. And so I would encourage you, and I don't think any record keeper would have a problem with it. And if they do, then that's when your prudent, alarm bell should be going off.
Yeah, thanks. I mean, that makes sense to me. And I think it's a tricky area just because, with these agreements, sometimes we see just a catch-all, will comply with all laws, but that doesn't really cover you with respect to ERISA because this stuff really isn't spelled out in ERISA anywhere. And what you're trying to do is cover yourself as the plan sponsor in your fiduciary duty and monitoring and selecting a provider. And that really comes to, I think, the details, getting more detail in that agreement about how that provider is going to protect your data, not only your data, but your participant data. You see the contracts that we see, I think, vary widely about how well they protect the employer in that situation. But I do know that there are some record keepers out there who just flat out say, we've got basically a guarantee. If somebody breaches our systems and takes your participant's money, we'll refund that money. We'll make that participant whole. I imagine that the devil's in the details of those provisions too, and that maybe errors in administration might not qualify. I think sometimes these are limited to truly security breaches. But I don't know, I'm just curious, in terms of these restitution type programs, what do you see regarding those?
Well, I love these restitution programs because what they do is, for a long time, a lot of agreements started putting arbitration provisions in, thinking that like if we stay out of the courts, everything would be better, right? Well, turns out arbitration is just as expensive and ridiculous as the court system oftentimes, right? So what I love about fraud restoration programs for record keepers is that it basically says like, look, we understand that bad things are going to happen. And so long as you're not willfully, engaged in malfeasance or willful misconduct or gross negligence, and we lose 250, 300K, million, we're going to do our best to get that money back for one. And we were just working with one of the major record keepers out there, major bank, and we lost about 380K. And 7 days later, the fraud restoration folks who were, doing this all the time, they got it back. FBI couldn't get it back. We worked with FBI. It was too late for them. But then this major bank and their team were able to get it back. And so by having those structures in place, you get the practical response first, which is, let's call all the banks, let's get the money back. And right now, there's a lot of like holds being put in place, like funds that are transferred have to be held for like 3 or 4 days. And so there is a mechanism to claw it back. Then, when you look at a fraud restoration program, like Vanguard has one, I think Fidelity's got one. We're advising a client right now on implementing one. They're also pretty nice because they tend to acknowledge that there may be some plan participant negligence involved, right? And they don't exclude that automatically, right? And so the cyber liability policies of record keepers should be robust enough to provide some protection for the record keeper to reimburse, say, several $100,000 or a million or so, and make those plan participants whole. And so if you think about it, lawyers get pushed out of that circle. The court system gets pushed out of that circle. And then you just have this kind of like close-knit group of folks working hard to get the money back. And then, I heard from one record keeper that, again, and we were fighting about it, right? We were fighting about what the fraud restoration program was going to exclude and what it wasn't going to exclude. And they just kept reassuring me. They said, Mr. Crow, 99% of the time we give the money, we make them whole. And I said, well, can we put that in the agreement? If that's what you do, and of course they were like, well, no, we can't. But my experience with those folks is that record keepers I think it's cheaper for them to make people whole, especially at the like $150,000, $250,000 range, than to like have a plan participant start suing somebody.
Yeah, I think that'll be an important question when plan sponsors do RFPs for record keepers to make sure that all of the cyber liability stuff is in that RFP, including whether you have a fraud restoration program.
Yeah, I think that's right, Jeff. I think there's going to be the standard of prudence could end up being there needs to be a fraud restoration program of some sort, right?
Right.
All right, with that said, it doesn't look like we have any questions coming from the audience. So thank you very much, both Jeff and Jason, for joining us. That was very helpful. I'm going to be honest with you, some of this still sounds Greek to me as far as the more technical aspects, but this was very helpful. Again, please note that we will be back with another session of our employee benefits lunch break series in July. So we hope to see you back on the third Wednesday in July at noon Eastern time. Thanks, everyone, and have a great month.